Hello, and welcome back to Business Law. These next couple of lectures, we're going to be discussing bankruptcy as well as secure transactions. I know they sound boring, but actually they're quite interesting and really very useful. So I want to start first with bankruptcy. Now, bankruptcy law in the United States is covered primarily by federal law, and that's stated in the Constitution. And why is that? Why is it that the drafters of the Constitution thought that it was important enough that bankruptcy law be covered by federal law almost exclusively? Well, suppose you had to declare bankruptcy. What might you be inclined to do? You might be inclined to, say, move from state to state, trying to figure out which state had the most favorable bankruptcy laws from your point of view. So the drafters of the Constitution wanted to avoid that. They wanted to just have basically one bankruptcy law. So 99% of all bankruptcy law is federal law. We'll talk about the 1% that isn't. Now, bankruptcy is currently governed by the Bankruptcy Reform Act of 1978. It's been amended several times since then, most recently, I believe, in 2005. The bankruptcy laws are commonly referred to as the Bankruptcy Code. They establish the procedures and the rules for filing for bankruptcy. Now, bankruptcy matters are heard in federal court, only federal court, federal bankruptcy courts. Now, they basically mirror the district court structure. So basically in each district court, there is a separate bankruptcy court. It is a federal court, and they handle all bankruptcy matters. Now, what's the purpose of bankruptcy laws? Well, as a funny story, I'm sure that you've all heard of the old expression, a pound of flesh. Well, where did that come from? Actually, that came from the first bankruptcy laws under ancient Rome. Rome had the first bankruptcy laws, and if you were declared a bankrupt and you didn't have sufficient assets to pay off your debts, well, what could happen is the creditors, the people you owed money to, they could literally get their pound of flesh. So you would be physically, your body would be divided in equal proportion to what you owed your creditors. So that's where the old expression, a pound of flesh, actually comes from. Fortunately, we don't do it like that anymore. That's not the way bankruptcy court operates. Bankruptcy law, why do we have bankruptcy laws? Well, in the broadest sense of the word, it's to provide the debtor, the one who owes all the money, who can't pay it back, with a, quote, fresh start. By freeing them from the legal obligations to repay those monies, to repay those debts. Bankruptcy laws, they operate, one, to protect debtors from abusive practices from creditors. Two, prevent certain creditors from obtaining unfair advantages over other creditors. That's really important. We're going to learn that not all creditors are equal. Some have a preference over others. Three, it protects creditors from actions by the debtor that would diminish the assets of the debtor, that would diminish the assets of the bankrupt estate. So it protects the creditors as well. Four, it is fast. It provides for the speedy, efficient, and basically equitable distribution of the debtor's non-exempt property. It moves pretty quickly, which is a good thing. And five, it preserves existing business relationships. A great example of that is Chapter 11 bankruptcy, particularly Federated Department Stores. Federated Department Stores now that includes Macy's, and Federated is now known as Macy's. They declared bankruptcy a long time ago in the late 80s, early 90s. And the fact of the matter is that if you had gone into any Macy's, you would never have known because Macy's, Federated Department Stores, they were able to maintain relationships with vendors to continue to supply goods for Macy's for sale. That was a good example of how bankruptcy law works. Well, how do you go about filing for bankruptcy? Well, so here you are. You're a debtor. You have a lot of debt. You cannot make even the minimum payments on that debt. Basically, you're insolvent. How is it that you go about becoming a bankrupt? Well, you have to file a petition for bankruptcy. You file a petition for bankruptcy with the whatever local bankruptcy court there is. Now, before you do that, you have to determine which chapter is the best one for you. Now, we're going to cover 3 chapters. We're going to cover Chapter 7, bankruptcy. It's not in the book, Chapter 7. It's in the Bankruptcy Code. Chapter 7, bankruptcy, also known as liquidation bankruptcy. And that's where it's available for individuals, partnerships, and corporations. Basically, the debtor's non-exempt assets are collected by the trustee, the bankruptcy trustee, at the court, and they're sold to pay off the creditors. That's known as liquidation bankruptcy, also known as straight bankruptcy. There is Chapter 11 bankruptcy. And this is available to individuals, partnerships, and corporations, but it's most often used by corporations. The example I gave, Federated Department Stores, is a great example of that. The goal of filing under Chapter 11 is to reorganize the debtor with a new capital structure so that it becomes viable long term. And finally, we're going to be covering Chapter 13, which is consumer debt adjustment bankruptcy. And that's basically for individuals. And when we mean consumer debt, what do we mean mostly? We mean credit card debt. So it's for people with really big credit card balances. It's a way of structuring out a plan to pay off those balances over a 3 to 5 year period, but we'll talk about that shortly. So Chapter 11. Let's start first with Chapter 11 bankruptcy. Now, Chapter 11 bankruptcy is also known as reorganization bankruptcy. Now, what that does, it's the debtor's financial affairs are put under the court's supervision. So the debtor, it's different than most bankruptcies. Here, the debtor is left in possession of the business. The debtor is in possession of the business. Now, normally, the debtor under Chapter 7 is not in possession of the business. There's a trustee appointed who oversees the debtor's business. But here with Chapter 11, the debtor remains in possession of the business. It doesn't mean that will always be the case. If the creditors can show cause why the debtor should not be in possession of the business, then a court can appoint a trustee. Now, with Chapter 11, the court appoints a committee composed of the 7 largest unsecured creditors. So the court, under Chapter 11, the court will look for the 7 largest unsecured creditors. Those are creditors that do not have any collateral to support their loan, to secure the loan. And that's a very important committee, because what happens is after the debtor files Chapter 11, they have 120 days to file a plan for reorganization, reorganization of the debtor's long-term debt, to come out with a new capital structure. The debtor has to provide, ample support for this plan. They just can't submit a plan. They have to show why they're submitting this plan. And usually it's a way of extending the payment plan, usually, but not always, not always. So then the debtor takes that plan to reorganize, and they submit it to that committee of the 7 largest unsecured creditors. There can also be a committee of the 7 largest secured creditors, or the largest secured creditors, period. But you don't necessarily have to be. When you're a secured creditor, you're in a different position. We'll talk about that shortly. So this committee of the 7 largest unsecured creditors gets the debtor's plan. Now the debtor, that's the one who has filed for bankruptcy. They get the plan and they vote on it. And if it passes, chances are the court will accept it. The court doesn't have to accept it, but in most instances, if the 7 largest unsecured creditors accept the debtor's reorganization plan, the court will as well. It's a good chapter. There are lots of examples of it, particularly in retail. Most recently, Saks was in chapter 11. But if you had walked into any Saks Fifth Avenue store, you would never know it. The shelves are still stocked full of merchandise for sale. All right, so that's chapter 11. Now, I'm going to switch now to chapter 7. Now, chapter 7, as we discussed, is known as liquidation bankruptcy. Okay? And that's when, basically, that's usually what most people think of when they think of bankruptcy. Now, the first step for chapter 7, of course, is to file a petition. Now, the petition can be filed by the debtor, or it could be filed by the creditor. So it could be voluntary if it's filed by the debtor, or involuntary if it's filed by the creditor. Okay. Now, in their petition, the debtor has got to list all their debts. And should the petition be accepted by the court, okay, the court will set up a bankruptcy estate and appoint a trustee to act as the legal representative of that estate. And what happens is the property of the debtor goes into that estate. So the property of the debtor is now controlled by the trustee. It is no longer controlled by the debtor. Now that as you can see, is already a big difference between chapter 7 and chapter 11. Now, what property goes into the estate? Into the bankruptcy estate? All non-exempt property. And we'll go over exemptions shortly. Now, why is it all that property goes into the estate? Well, all that property will eventually be sold off to pay off all of the debtors. Now, all of the creditors. Now, not all the creditors are equal. There is a hierarchy, and we'll go over that shortly. But first, let's talk about what property goes into the bankruptcy estate. Now remember, the trustee controls the bankruptcy estate. All of the debtor's property, non-exempt property, goes into that estate to satisfy the creditors. It'll be sold off for cash, aka liquidated, and then the creditors will be paid off. As we'll learn though, for the most part, most of the creditors will only get 1 or 2 cents on the dollar tops of the debt that was actually owed to them. So, property that's included, well, it's really any property in the debtor's possession that has been acquired before the filing of bankruptcy. But what is exempt? There are exemptions, and there are a couple of basic exemptions, and then the states can add to them. The first exemption is referred to as the homestead exemption. Now, that's interest in real property up to $17,425. Now, the real property, that could be your home, or it could be your burial plot. So, if for whatever reason your home isn't worth $17,425, you get to keep it. Or if it is sold off, you get to keep what? $17,425 from the sales proceeds. So that's in your residence or a burial plot. Interest in any property up to $925 plus $8,725 of any unused portion of the homestead exemption. So if for whatever reason you didn't use your whole homestead exemption, you can use up to $8,725 worth of it, as well as $925 in any other properties that you may own. So you get to keep that amount. when they're sold off. Interest in one motor vehicle up to $2,775. So if you're in bankruptcy, they don't want you driving around in a brand new Lexus. You have to get a used, old car. They don't want you driving around in any kind of luxury vehicles if you're in bankruptcy. Interest up to $450 per household item. And that includes furnishing, clothes, appliances, books, animals, crops, musical instruments, up to an aggregate value of $9,300. So all that is exempt, from your bankruptcy estate. All value up to $450 per item, household item, up to an aggregate of $9,300. So you can't surpass that amount in value in total. Okay, interest in jewelry up to $1,150. Does that seem like a lot? Not really. I mean, especially now with the price of gold and precious and semi-precious stones, it's really not a lot. Any unmatured life insurance policies, they are not included in your bankruptcy estate. Now, there are two types of life insurance policy. You have term and you have whole. Now, term, that's when you pay a yearly premium, and the policy covers you for that premium year. So, if you pay a $1,000 premium for $500,000 in coverage, life insurance coverage, for that year, if you die within that year, your beneficiaries get $500,000 should you die. Now, whole life insurance policy, now this is what this exemption really speaks to. A whole policy is a little bit different. You actually build equity in your policy as you continue along. Now, originally, a whole policy doesn't have a lot of value. In a sense, it's almost kind of like a savings account. So suppose you had a $100,000 whole life insurance policy. Well, the first couple of years, that policy is not worth $100,000. It's worth, whatever you put into it. So you pay the premium, say $1,000. And you get interest in it, So after a year, that $100,000 policy is only worth what? $1,000 plus some interest. But then the next year, you pay another $1,000 premium. So now you have $2,000 in premium plus 2 years worth of interest, et cetera, et cetera. There's a value there. That's a cash value. It's unlike a term policy. A term policy, once you pay the premium, that's it. You're done with. You don't have any other monies. But you don't get your premium back. But with a whole policy, you basically get to keep the value of your premium. So it's like a savings account in a way. And any unmatured life insurance policy, that's excluded from the estate. Health aids, anything that you use to get around. I mean, I think about, wheelchairs and canes and stuff like that. Those are exempt. Government benefits like Social Security, welfare, and unemployment compensation. Those are also exempt from a bankrupt estate. So you get to hold on to those benefits as well. Alimony and support payments, pensions and profit sharing and annuities. Those are also exempt. If you're receiving any alimony payments, support payments, pension payments, or profit sharing distribution, those are also exempt from bankruptcy estate. Wrongful death benefits and life insurance proceeds up to $17,425. Okay. So if you are the beneficiary of someone else's life insurance policy and you receive, say, $30,000 from that policy, you get to keep $17,425 of it. Interest up to $1,750 in tools, equipment, books, and anything else used in the debtor's trade or profession. Now, states can also add their own exemptions to this. So this is where state law kind of comes into play. They can also add their own exemptions to it. Okay. Now, what if maybe some of you are thinking, well, if all this, if all this property is going into my bankruptcy estate, well then why why should I hold on to this property? I should give it to my family. I should give it to my friends. I should give it to my business associates. If my creditors are just going to get it, I'm going to take all of my assets, right, that would otherwise go into the bankruptcy estate, and I'm going to transfer them to people I know and trust and love. Okay. Well, you can't do that. You can't do that. Um, Um, there are a couple of the bankruptcy code takes that into account, um, and it can void those transfers. The court can void those transfers and pull those assets back into the bankruptcy estate. You have preferential transfers made to insiders. Uh, any transfer made within a year of filing bankruptcy to relatives, partners, partnerships, corporations, or whoever, any transfers made within a year of filing for bankruptcy, those assets, they come back in. They come back into the estate. So it's any transfer within a year of filing for bankruptcy. Then there are also fraudulent transfers. Now here, we're talking about a guilty mindset that the debtor is actually attempting to defraud the creditor. Here, the court can just collect those assets back into the estate, regardless of how long it has been, a year or longer. All right, so you file for bankruptcy protection under Chapter 7, also known as liquidation. All of your non-exempt assets are going to go into the bankruptcy estate and sold off. Now, and you get to keep your non-exempt assets. You get to keep your exempt assets, what we just described. So all the non-exempt assets are in the bankruptcy estate. They're sold off. Now, who gets what and when? Well, the first one to be paid off are secured creditors. Now, we're going to discuss secured creditors shortly. Basically, secured creditors, they're creditors that have collateral. They have collateral on the debt. So a good example of that would be, for instance, probably the most common, or one of the most common examples, a note and mortgage, right? The bank lends you money to buy a home. You buy that home using the bank's money. Now, in most states, you own the home, but the bank has what? They have collateral. They have a lien against your home. So if you fail to pay your debts, the bank eventually can seize the home to satisfy that loan. They are a secured creditor. Secured creditors are paid first. Next, uh, all fees associated with administering the bankruptcy estate. That includes, for instance, court cost, trustee fees, which can be quite high, attorney's fees. Now keep in mind, the trustee is the legal representative. The trustee is the attorney for the bankruptcy estate, not the creditor. I'm sorry, not the debtor. Okay. The debtor has to have his or her own attorney. The debtor has to have his or her own legal representative. Okay. So next, after secure creditors, we have all costs associated with administering the bankruptcy estate. That includes court costs, trustee fees, attorney's fees, appraisal fees, and the such. They're paid next. Who gets paid after that? Well, um, I had mentioned before that a Chapter 7 petition for bankruptcy can be filed voluntarily, e.g., by the uh, uh, debtor, or it can be filed involuntarily by the creditors. Now, if it's filed involuntarily, in other words, the creditors have decided to throw the debtor into bankruptcy, the next one to be paid are secured claims by gap creditors. Now, those are people who have sold goods or services on credit to a debtor in the ordinary course of business from the time that the debtor filed for Chapter 7 bankruptcy to the time a trustee was appointed. So they're in that gap. Okay, so in other words, the debtor, okay, has filed for Chapter 7 bankruptcy. Okay. The debtor is continuing to do business. They are buying goods and services on credit, on secured credit. In other words, there's collateral. They are paid next. The secured claims of gap creditors, they are paid next. Third, unsecured claims for wages, salary, and commissions earned within 90 days of filing for bankruptcy, filing the petition, up to $4,650 per employee. They're next. Um, After that, unsecured claims for contribution to employee benefit plans incurred within 180 days of filing for the bankruptcy petition. Uh, After unsecured claims for contribution to employee benefit plans, farmers and fishers, they're paid next. Why? I don't know, but they're paid next. If the debtor owes a farmer or a fisher money, they get paid after that. Um, Unsecured claims for deposits, for cash deposits up to $2,100. That's next. Debts owed for child support, paternity, alimony, and spousal support. That's next. Your ex-spouse and your children, they're paid after farmers and fishers. Okay? After family payments come income taxes. You got to pay your income taxes, but they're paid next. And last but not least, we have general unsecured claims, basically credit card debt. They're paid last. Now, from a practical point of view, once you get past the secured claims, the cost of administering the estate, and the secured claims of gap creditors, the rest of the creditors realistically get 1 or 2 cents on the dollar. Now, what happens? So, at the end of all this, so all that money is your bankruptcy estate is sold off, it's liquidated for cash. Everyone is paid off. What happens at the end? Well, the debtor's debts have been discharged in bankruptcy. In other words, the debtor is no longer legally liable for those debts. Well, at least for most of them. Most debts are discharged, but there are some debts that continue, that are not discharged. And I want to go over that next. Which debts are not dischargeable? One, taxes accrued within 3 years of the filing for bankruptcy. Those debts, they're not discharged. Two, fines and penalties payable to any federal, state, or local government. Those are not discharged. Three, claims based on the debtor's liability for causing intentional or malicious injury. In other words, intentional torts. So if the debtor is found liable, say, for assault and battery, intentional torts, that debt is not discharged by bankruptcy. Claims arising from fraud, larceny, or embezzlement while the debtor was acting as a fiduciary. So, for instance, Bernie Madoff. If Bernie Madoff were to file for bankruptcy, all those debts would not be discharged. He was certainly acting as a fiduciary and committed a lot of fraud, a lot of larceny, and embezzlement. Alimony, maintenance, and child support. They may be last or close to last to being paid off, but those debts are not discharged, so they remain in effect. Claims based on the consumer, on the debtor's purchase of luxury goods of more than $1,150 within 60 days of the order of relief. In other words, the bankruptcy petition has been granted. So the debtor just can't go out and start buying stuff. They're still liable. Cash advances up to $1,150. Those are not dischargeable. Judgments against the debtor for any liability incurred as a result of DWI. So if the debtor went out and was arrested for DWI and had caused an accident, they're still liable for any injuries they may have caused. Any state or federal court order, judgment, or decree arising from a violation of federal or state securities laws. Again, using Bernie Madoff as a great example. There are lots of judgments against him. Those judgments are not dischargeable because they're all based on violation of federal and probably state security laws. Okay, so that's Chapter 7, Complete Liquidation Bankruptcy. Now, what if, for instance, you were an unsecured creditor, a general unsecured claim, and you're a credit card. You represent a credit card, I should say. You can't be a credit card, but you represent a credit card company. And you get they get the Chapter 7 petition, and they know that this particular card holder has filed for bankruptcy, and you know that what? Basically what? You are going to be at the bottom of the rung. Are you stuck? And you're thinking, actually, this debtor, they have a good paying job. They have assets, maybe even significant assets. And you're thinking to yourself, well, why are they declaring Chapter 7? Why are they declaring Chapter 7 bankruptcy? They could pay off more. I mean, you're only going to get 1 or 2 cents on the dollar, but you're thinking they could pay off more. You might force them to file under Chapter 13. Now, Chapter 13, as I mentioned before, is consumer debt. Is also known as consumer debt adjustment. In other words, large credit card bills. Now, with consumer debt adjustment, the point is that the debtor can actually pay off a lot more than they're telling the court that they can. So the issue then becomes, well, should the debtor file under Chapter 7 or Chapter 13? The debtor may want to file under Chapter 7. The creditors may think, no, Chapter 13 is really the chapter they should file under. In determining which chapter to file under, courts will apply what's known as the means test. Now, the means test, it can be complicated, but it comes down to really 2 different factors. Okay. First, look at the debtor's income. If the debtor's income is less than the state's median income for a household of that size, if it's less, they can file under Chapter 7, no questions asked. So if the median income is, say, $40,000 for a family of 4, and they only make $35,000, no problem. They can file under Chapter 7. That's the end of the inquiry. What if the debtor's income is more than the state's median income? Well, then it gets a little bit complicated. What will happen then is you have to determine disposable monthly income. So disposable monthly income. So that's income after paying things like necessary living expenses and required debt payments. And you look at that over a 6-month period. Now, if the disposable income is enough to pay at least 25% of the unsecured debt, or $10,950, whichever is less, over a 3 to 5 year period, if it's enough to do that, then the debtor has to file under Chapter 13. Now, there is a difference between Chapter 7 and Chapter 13. With Chapter 7 bankruptcy, it really, it affects the debtor's credit score tremendously. Chapter 13, it still affects the debtor's credit score, but not to the same extent. Why? Well, they actually have paid at least 25%. I mean, under Chapter 7, they would have paid maybe 1 or 2% of the general unsecured claims. Under Chapter 13, they're actually paying at least 25%. So it's less of a hit to the credit score. Sometimes debtors prefer to file under Chapter 13 than Chapter 7, knowing this. So, sorry, I'm just checking on my cat. I'm surprised she has not made an appearance yet. All right. So suppose it's determined you have to file under Chapter 13. Well, what's next? Well, the debtor has to file a payment plan within 15 days of the petition being granted. And the payment plan has to pay off at least 25% over a 3 to 5 year period. And if it's acceptable to the creditors, then chances are it will be acceptable to the court. Um, but you can see that's pretty quick. Potentially 15 days after the petition is granted, the matter can be over. I mean, that is lightning fast in the legal world. Um, so that's it. So we went over bankruptcy law, we went over chapter 11, chapter 7, and chapter 13. Each one, has different advantages and disadvantages. Um, all right. So our next lecture, we're going to be covering credit and suretyship. So continue with the good work. Thank you.